here for a minute?
Yeah, we need
Oh, what did she leave? Then I guess we can't.
Sorry about that.
That's okay.
Got it? Maybe, you want to start it, do it while you're. Yeah.
We're off the record. Mike and I were talking, so if he's late, it's my fault. I was late.
We're okay.
That's right.
Did you start it again?
Everybody set?
Yes, sir.
Okay, let me call to order the Town of Waxahachie Grove Special Magistrate Hearings for today. Today's Wednesday, February 20th, 2013. It's 2 minutes after 10 a.m. Let me, I guess, begin by swearing the witnesses for whoever may be testifying today, and then we'll just go on with the agenda. So if you're here to testify, anybody else going to testify? A lot of people here. Do you swear the testimony you will give me the truth, the whole truth, and nothing but the truth?
Thank you.
Thank you.
Mr. Downey, before we begin, Mike Cirillo, Town Attorney, just to refresh where we are procedurally, it was back in, I think it was the December hearing in which the city presented its testimony and evidence in support of the violation. At that time, it was agreed that we would continue this matter prior to you having an interim order so that we could provide some time for the respondent to proceed forward on some applications with the town. The last meeting, which was in January, there was an agreement on the record for an additional continuance, provided that by last Friday, the town received an application that was responsive in all respects to the requirements of it. Whether it was deemed sufficient or not, at least there was something for each of the items. We're here today, and I don't want to mischaracterize anything, but it was our position that that wasn't sufficient on Friday. Mr. Brown wants to address the court, though. He has maybe a differing opinion, and rather than characterize that, I'd like to give him the opportunity to address you directly on what he'd be requesting this morning, and then I can respond to, if needed, to anything that he says, unless you object.
Mr. Brown.
Yes, Your Honor. May it please the court. Jeff Brown on behalf of both Elaine Smiley and Seth Ryder. Michael is correct in that at the last meeting, which I attended by phone, Your Honor issued an order with all of our agreements setting forth where we were. And I would ask the court to take a look at that stipulation, because I think paragraphs 1, 3, and 4 apply. 1 talks about filing the application and the filing fee. And I think it's very important for the court to consider that, since I'll tell you right now what we're asking for. We're asking for the court to continue this 30 days. And Michael is fine with the 30 days, and not to mischaracterize him, I think he's not fine with you not taking any further action today. So we're close, and yet we're not there. Paragraph 1 talks about filing the application, including, I believe it talks in here somewhere about all filing fees. And I think, Your Honor, that's very important for 2 reasons. He brought a check for $7,500, which is the amount they asked for. So that is not in dispute, the payment nor the amount. So he brought that Friday. In addition to that check, and I will later, Your Honor, be arguing that he has put his money where his mouth is, if I can use that analogy. It doesn't really come from a court case, but he has put his money where his mouth is. And he has also submitted the application. Now that application, I'm going to agree with Michael, is not in perfect form, and it is not in final form, and he needs to hire a professional land planner. And I'll address that right now. He had a land planner named Mr. Kildare, and there's a letter that I can submit to Your Honor. But among the things it says is I have received your 2 surveys, I have reviewed your 2 surveys. The plan we need to go through requires a reasonably long process. So I can provide the court with that letter from Mr. Kildare. Unfortunately, Mr. Kildare is not able to proceed, and Mr. Breyer has to hire a different land planner, and he has to hire a land planner, because I agree with Michael, he's not going to be able to do this thing, as I call it, pro se, or as a landowner. So we are asking for 2 things, and Michael doesn't disagree with these 2 things, and that is that he retain a land planner and that he meet with the city within the next 30 days. So all we're asking of the court is that, pursuant to paragraph 1, we be allowed to submit our application. We have submitted it, that it be accepted in the form it's in, and we have received an email with the things that need to be worked on, and that the city accept his $7,500 application fee. That's going to be important, I would suggest, for 2 reasons. That invests him in the project in a monetary sense, and I do think that protects the city, because we are making tremendous progress if he has paid the application fee and submitted the application. Where Michael and I disagree is as to paragraphs 3 and 4. And the reason I'm skipping 2, Your Honor, is that it's really not applicable. That talks about if he doesn't do anything, then we proceed with the hearing. Paragraph 3 talks about if we disagree, then we appear this morning and either proceed or otherwise address it. That's what I'm doing before Your Honor as we speak. And then, Your Honor, paragraph 4 allows the city the protection it needs. It has 2 protections. It will have the $7,500 application fee, and it will allow them to proceed if they, for any reason, feel as though we're not diligently pursuing that which I'm stipulating to you today, which is that he will retain a land planner, and that retained land planner will meet with the city within 30 days. So our request this morning, Your Honor, is to continue this for 30 days, accept his $7,500, required by stipulation, and I will be happy to draft the order, Your Honor, that he retain and meet with the city within 30 days. The only way Michael and I differ is, I guess I'm speaking for him just a little bit, he can't agree, as I understand it, with continuing it on this basis for 30 days, that I believe he would like to proceed with some version of the hearing today, which of course I will agree respectively if the court goes forward. But in the interest of judicial economy, and given the fact that he's paid his filing fee, I would suggest it is more advantageous for both the city and the landowner to proceed down this progressive path without a couple hours hearing as we present testimony, and then submitted to Your Honor for a finding that will be subject to this application respectfully in any event. So to summarize, I'm asking the court, pursuant to your paragraph 4 and your paragraph 3, to suggest either we have responded under paragraph 1, even though we don't have their agreement to cancel it, but in light of the developments, that between paragraphs 1, 3, and 4, you continue it for 30 days. I have checked my schedule. I am available. I'm hoping that we can not have a hearing, and the order that I hopefully will draft for Your Honor's signature, would suggest that we have a hearing set, but again, like paragraph 1, it can be canceled upon agreement of the parties, and I fully intend will be in that we will have the protection for the city, that if they feel that it's not diligently pursued, they can return and remind the court of this long-winded speech this morning, and we can then proceed.
Okay, I take it that's not acceptable.
Hello, Mr. Downey. Good morning again. I'm Mike Sewell, I'm attorney. When we were here at last meeting, I think we were very clear that what we expected to see by Friday, which was an application for the needed changes, the land use and special exception, that contained responses or information to everything that's in an application. We did put that on the record. That list, that stipulation is not expressly in your order, but that's the reason why we disagree this morning. We did provide the respondent with a letter yesterday, which I would like to, I know they were provided a copy with, but I would like to submit for you to review. It's the city's planner's assistant's review of the application, indicating what was deficient, missing, or whatnot. And rather than paraphrase, I'd like you to just review the letter, and then I can continue on with what I'm asking the court for. So unless Mr. Brown objects, I'd like to demonstrate it was provided to you yesterday by email.
I have seen it. I do not object. I would only note for the court that Mr. Kilday has acknowledged he has 2 surveys from Elaine Smiley and Mr. Breyer, and therefore, among the things they address is no surveys. He has 2 surveys, will submit them, but couldn't Friday because they were with his previously retained landlord.
Okay.
Barring that, obviously, we have some responses to that.
Well, can I?
You certainly may get to.
Okay.
Wait a minute, this is the.
Well, no, but I want it marked to the proper number. We're only up to number 9. This month. Okay, you got it? Okay. So let me show it to Mr. Brown then.
Is this the letter
This is the
yesterday?
letter from yesterday.
Yes. I have no objection to his review, subject to us not agreeing to every word within it.
Okay. Well, understanding it was written by the town, I would expect you to agree with everything in there. But this is marked as Exhibit 10. I will admit it into evidence. I'll take a minute.
It should be Exhibit 9.
I've marked through it, or there's.
Is it not marked on the bottom of the letter?
Okay. Bottom of the letter has, I'll mark that as well.
Thank you. Okay, thank you.
But yeah, the cover page has 9 and the document has 10 on it, so
So I'd like, if you would like, to give you a moment to review that, and then I can conclude, hopefully, more brief than Mr. Brown.
let me just ask a question to put this in context for me. The applications that were filed, were they filed by Mr. Kilday, or were they filed pro se, if you will?
Pro se, if you will, Your Honor, and if I can address that, the application is here in some fashion, and his check is here in some fashion, and he has brought the physical check. So I didn't want to waste time and start having it marked as exhibits. He has the check, the application is here, and I skipped over those exhibits subject to asking the court in the interest of judicial economy to visit this in 30 days.
And Your Honor, that was one of the main issues that we have with how this case is progressing. I mean, this complaint was filed in 2011. We started having hearings last summer, and we had an actual hearing in December. The last hearing, we continued based on the representation that a land planner had been retained. We did have that letter, it was put in evidence, it was Exhibit 8, the last hearing. And then since that last hearing, we've, for all intents and purposes, from our perspective, all we've got is some paper filed with it pro se, no planner, and in fact, the check was not even left with the town on Friday. A copy was left with the town. Mr. Breyer did not feel comfortable leaving the check for the filing fee at that time. I guess that position is now different this morning, but that was also a consideration of why we're here, that we got a pro se that was insufficient from our position on a page. There's over a page list of items that are required to be in there. Understanding, of course, that it was pro se, that we would expect that to happen. That's why it was important to us before the last hearing that a planner had been retained. That planner is no longer involved from what we've been told. There is no planner engaged as of today. And, quite honestly, we're concerned that a further continuance drags us out another 30 days. And then we'll be back here at the next hearing with maybe something additional, but still something that's not sufficient. Because all we're going to get within the next 30 days, at best, is the check, the planner retained, and planner meeting. We would not expect to get within 30 days a complete application. So what the town is requesting is that we proceed with the hearing. If your Honor finds a violation, there should be sufficient time to bring it into compliance before a fine is imposed. But this way, we know that there is a time certain and a deadline to get things done, because if we continue it for 30 days, we still will have a hearing. You're still going to have to provide sufficient time to bring it into compliance at that time. So we object to a continuance, but again, your order was left it to your discretion this morning to determine how to proceed. And if you need to hear from anybody in the town to support what's in that letter, I'd be happy to call them, but I don't think that's necessary. It really rests with you at this point.
Let me ask this, and I'm not presupposing a violation, but if one were found, would the town then be of a mind to agree to give enough time to process this sort of application?
Well,
Because I guess.
well, hypothetically, we would have to. You would have to put on the record the time it would take to do things. And I don't want to get too far ahead, but again, that's why we object and we want a hearing, because, if there's a finding and there's a time frame, then everybody knows what we're working with. And right now, there continues to be uncertainty from our perspective when we can expect this thing to be brought to conclusion. And we're also 30 days, 60 days closer than we were at the last hearings to the end of the moratorium, which is at the end of March, where we could actually begin in earnest moving this forward for reviews. And this last 30 days pushes that probably right now into May or June, when we were expecting, based on the last timeline, we'd be able to hit the ground running in April. So, the town is frustrated, but, again, it's left with you to decide how to proceed this morning.
May I address your question ever so briefly?
Sure.
With the paragraph 4 language about due diligence, I think the city's protected. With the application fee being accepted, I think the town is protected. And the alternative of proceeding with a hearing on the merits today will probably be a couple of hours, and unnecessary in the interest of judicial time, since we are stipulating to that which we must do within 30 days. So they have simply just said the very things we're promising, and I just think that's a better road to go down this morning.
Mr. Downey, can I suggest something too? Sure. For representations of council, maybe the respondent can tell us on the record what they expect to do in the next 30 days, and that would, and maybe that'll assist either way in your review of this morning.
Sure.
And I would agree with that, Your Honor.
Okay, I don't know how you want to address that. You just tell me what your plans are for the next 30 days. Well, let me hear that first. So what do you plan to do? Do you have a land planner lined up?
I do have 2 meetings on Friday with 2 different land planners to choose one of them. I had Carrie Kilday working as one of the land planners. Things didn't work out, and I submitted the application with every signature, every notary, as complete as possible. I also brought in the cashier's check to Mark, and we discussed him issuing me a receipt for the cashier's check on the date that you said that it had to be done, which was by the 15th, Your Honor. I also got issued a receipt of the application on the date that you said that it needed to be done, Your Honor. And the land planning is out of my control without a land planner. The application is incomplete because I'm not a land planner and cannot fill that out. So my plan is to have a land planner to fill that out and meet with the city and be able to get this accomplished. The land planning is a very timely process. These traffic studies and things that need to be done take much more than 30 days. So I don't know what else more I can do, and I'm either submitting an application, I'm submitting a cashier's check for $7,500 for the cost recovery fees with a moratorium in effect, that there's no applications allowed to be submitted at this time, that there's no payments allowed to be submitted at this time. We're not even sure that the town council will vote to lift the moratorium in March or April, whenever the hearing is, but I'm trying to comply in every way that I possibly can as a landowner.
Just to clarify one thing, the town council doesn't have to vote to end the moratorium. The town council would have to vote to extend it, and it doesn't appear that that's going to, at least I haven't been told we're going to request any further extensions, but
So it expires on its
it
own.
expires on its own unless they undertake some action to extend it.
Okay, thank you.
When was the original notice of violation?
I believe May, Your Honor.
May of last year?
20,
I've got it here.
well, I believe you're right.
By Exhibit 1 was we got a complaint in November of 11, but the correction notice was sent in March of 2012. And the notice of violation, the first notice of violation was in May
Yeah, and one other
2012.
thing, not that it particularly matters, but the hearing we had was back in October.
Yes.
Okay.
So we're back that far rather than
December.
December.
So,
And then we were last month, we
Shows my age, time's flying.
goes faster and faster.
Yeah, it does.
Okay. To the extent, I guess, that this is a request to continue the hearing, I'm going to deny that. I think for this reason, that the town was very adamant. I think 60 days were asked for last time, and the town was very adamant, and my thinking as well was that, we'll give the property owner a chance to move this along, but the goal and the purpose of the continuance in January was to make sure it moved along. And I understand you're not a land planner and all, but it looks like a fairly minimal application was filed and the fee wasn't submitted at that time. And I think it's correct to bring it in under paragraph 3 is that he meet that basis, but it doesn't seem so. And my concern would be, and even with the language in paragraph 4, what's due diligence and that sort of thing. But my concern is that it's not moving, from the notice of violation and such. Things aren't moving. And there was sort of a last chance to get it moving last meeting, and the order entered on January 22nd. So I'm going to deny the request for the continuance, and I guess we go on with the hearing. Now, the hearing, the town had rested, correct?
Correct.
So we're on to whatever the respondent would like to present.
We'd call Seth Pryor.
And let me just refresh my memory here. There were 2 alleged violations, I guess. One, and I'll maybe oversimplifying them, one would be running or operating a retail operation out of an area where that was not permitted. Is that a fair summary of the charge?
yes, sir.
And then the other was one that there was a Attorney General's opinion being requested for.
Yeah, that one.
Those charges were abated.
Yeah, we're not proceeding on.
So that one's just out there.
Yeah, we haven't resolved, we did get the AGO. It did interpret the statute to exempt certain types of buildings from our ULDC. We just haven't gone back to revisit that issue. That's not before you. We're only here on the first, which is the retail use on the property, and nothing to do with the permits or the structure.
Okay. Okay.
I've been licensed for many years, Your Honor. I have several licenses. I've been running the same business. And I was licensed in Palm Beach County, and then the town took over. We had this issue arise where the same person who filed a complaint in 2008 the complaint went before the town council. The town council agreed that the property completely surrounding my property was being designated for commercial, and that if I were to vote along with it, we would be in the commercial designation for Waxahachie Groves. This was before Mark came in and Frank Spence was the town manager. The charges were dismissed or tabled or what have you, and then they were filed again in 2011. We still have the same licenses. We've still renewed the same licenses. I'd like to pull into evidence, if we could, the hearing from Southern Boulevard Workshop the other night, where Jim Fleshman, who is the town land planner, actually stated that any permitted uses for the property that were prior to the town becoming a town are allowed in the town of Waxahachie Groves. They have it on video. We're trying to get it on the overhead, and I would like to, Your Honor, to do that for 1 minute, please.
We can do that, but I would think, and there's provision in the town code saying that the grandfathering, correct?
Yes.
So I mean, that's what we would be looking at as much as what Mr. Flushing's opinion
Right.
is.
That's correct.
I
I could go along with the grandfathering due to all the licenses I have, Your Honor, but the town and I came to an agreement that said, okay, we're not going to proceed that road. What we are going to proceed is we'll do a land use change. So if you hire an attorney and you go to court and your attorney, you decide to fire your attorney, or your attorney decides no longer to represent you, you ask Your Honor for a continuance to find new counsel, to hire new counsel. Well, that is exactly what happened with my land planner. That is exactly what happened, and that's why we asked for a continuance to find a new land planner, to find new counsel. We're not asking for anything that is out of the ordinary. I was there with the check, with the application on Friday. I received a receipt for the payment. I received a receipt for the application from the town on the date that you specified, which was February 15th.
Well, I've already addressed that part of it.
Okay.
So we need to get on to the...
I know that you've already addressed it, Your Honor, but the simple fact is, I did what you asked me to do, okay? The stuff that is not in my control of having a land planner, that is not in my control. That's the reason why we are requesting the continuance that you've denied, okay? But all we're asking for is additional time to hire a land planner so the application that we submitted will be more complete. A land planning process cannot be, it takes years to do a land planning process, Your Honor. There's nothing that can be done in 30, 60 days. I mean,
Well, we need to address that, assuming there's a violation. But let me ask a question. Is your position, maybe this is a question for Mr. Brown, is your position that you're grandfathered, or is your position that you need to get that commercial designation so that your operation is legal under the town zoning? Because that would make a major difference. Because if you think you're grandfathered, I mean, you need to present that to me, and if you are, then I would not think there's a violation.
right.
Okay.
Yes, sir. I feel that I'm grandfathered, and I don't believe that there's a violation. Do we go ahead and proceed with the application based on the meeting that we had in Delray Beach at Mike Cirillo's office to go ahead and file for land use change? Sure. But do I believe I'm in violation? No, Your Honor. I've been licensed. I've paid $3,000 a year since 2004, 2005, 2006, 2007, 2008, 2009, 2010, 2011, 2012, 2013. That's almost 10 years. That's $30,000 in license fees, Your Honor, to operate a business. There's also a law by the name of ipso facto. Once you are in business, you're not retroactive allowed to be put out of business, even though the town changed. I was licensed under Palm Beach County before Loxahatchee Groves was even brought into effect, before it was even established as a town. I've been doing business prior to that. So there's no reason for me to have a violation.
I think the question is, what were you licensed to do?
I'm licensed to run hay, feed, and tack sales and variety store. And that's exactly what we do, Your Honor. Those are what my licenses are specifically for. I have 28 other licenses to do business on that property as well, Your Honor, that range from airplane manufacturing of parts, to mulch manufacturing, to mulch storage, to RV storage, to, I have a numerous list of licenses that I've renewed every year since 2004. There's 28 different licenses that I hold on that property to operate businesses.
And these are 28 licenses from the town?
From Palm Beach County, Your Honor.
Okay, so they're not from the town?
They've never been from the town. I've been licensed prior to the town ever being a town.
Okay, anything else you want to tell me?
Yes, Your Honor. in answer to your question, we have parallel positions. One is that he's grandfathered in for actions that he took before the town was annexed. We also have a parallel position that we're attempting to comply with a new city, which was annexed sometime in 2000, mid-2000s. And we're trying to work with them and their new codes and their new laws as a result of them being annexed and the cooperative landowner. So we have a parallel position in answer to your question. We would ask that your first, Seth, you have the earliest license that you got from the county?
I do.
Now, Michael, do I give this to the town clerk to be marked as landowners number one?
Yeah, and I'd like to see it, and then they make argument based on, at that point.
And as we're looking for the first license, Mr. Breyer, was this before there existed the town you're now talking with and about?
Yes.
Let me just get that date in my head. The date the town was incorporated was?
I think effective October 2007.
Mr. Breyer, did this license that you're going to hand me and I'm going to hand him my predate that date, meaning before?
You have to give me a minute to find it. There's so many licenses. This was effective January 1st, 2007. That was prior to October of 2007.
And what did that allow you to do?
To run a variety store.
And is that what you began running back then?
Yes, sir, it is.
Are you still running it today?
I am.
Have you made any changes to your operations since the annexation of the city?
No, it's been the same, Your Honor.
You can move this in as landowners one.
Okay, any objection?
Well, I would object, and I can go through the legal argument. First of all, I would like to see if we can stipulate, or we need to go through this to ask him, but that there were no local business tax receipts or occupation license issued by the town of Waxahachie Groves itself. I don't know if he's got one, I'd like to see it, but I think we should be able to stipulate to the town itself that all the occupational licenses or business tax receipts that Mr. Breyer has were issued by Palm Beach County.
Michael, I'm sure if you suggest it, I'll agree.
So, Then the next thing I would point out is that all of local business tax receipt or occupational licenses is a payment of a tax that gives you the right to do business, but it doesn't give you the right to do business wherever that business is. And I've got the case which I can provide a copy to Your Honor with, and I can give the site to Mr. Brown, allow him to review it. Ammons versus Okeechobee County, it's a 4TCA case. 710 Southern 2nd 641. And in that case, a local business tax, or at that point, an occupational license, was issued when the zoning did not allow the use at that location. And the court upheld the ability of the county to rescind that, saying that a local business tax, all that does is provide the authority of the person to conduct the business. But the court went on to say the appellants, which in this case would be the respondent, are on constructive notice of the contents of the ordinance, are presumed to have constructive knowledge of the nature and extent of the powers of the government agents who issue the permits. It's not a zoning issue. So he can provide you with local business tax receipts for his businesses, but it doesn't change the fact that those businesses don't fit the zoning code. And we can provide evidence to that, but they've got a burden to show not just that he's paid taxes to Palm Beach County, or that he's even operated. If he's going to go with grandfathering, he's got to demonstrate that that was legal before the town came into existence. And that requires him to show that the uses that he had on that property were allowed under the Palm Beach County zoning code. We don't have to show they weren't allowed. He's taken on the affirmative obligation to show an affirmative defense of grandfathering. He's got to show that this variety store was allowed under the Palm Beach County zoning code for it to have been legally established before the town incorporated. And so, because, you know, otherwise you're allowing tax receipts or the clerk's office to amend the zoning code by just accepting payment for taxes. And they don't have any authority to do that. I don't. Mark doesn't. Only the town council, or in this case, the county commission can. So I would like to provide Mr. Brown, put on the record and give the site 710 Southern 2nd 641. And that's Ammons versus Okeechobee County. It's a 4th PCA case from 1998. If you'd like a copy, I can provide it to you.
Yeah, you would.
So that's why I'm objecting to local business tax receipts coming in,
Yeah.
because they're irrelevant to the determination of zoning and whether it was appropriate under the zoning code.
Does someone have a copy of the town's non-conforming use provision? They have to take a look at.
Are we also working on what I asked to get up on the screen?
Do you have it?
Residential zoning
We're gonna pull it up.
definition.
Okay.
Do you have those sections?
Yeah, but
Sure.
you just keep that copy.
Michael has agreed to provide copies of that by email later. Your Honor, as I introduced landowners number one, I would suggest that goes to weight and not disagreement.
Yeah, I would admit it into evidence. I do though, and I'll just say this much, that and I want to look at the town code, but my understanding of grandfathering and all is in order to be grandfathered, one must be legal at the time or before the change in the code. Okay, so.
And I have case law on that.
Yeah, that's my understanding of it. So if your use was consistent with the zoning code in Palm Beach County prior to the incorporation of the town, it would seem to me that you would, and again, it would be the town code, it would seem you might be grandfathered. If at the time, though, you were operating and you were not a legal use under the county zoning code, then I don't know that you have the legal non-conforming status to come forward and say you were doing it. So I think that's what the law is, and I think that's what we ought to address as far as.
Yes, sir, I was operating and I was licensed and I was operating prior to the town becoming a town.
Okay, the distinction now, I think, and this was Mr. Cirillo's comment, is that having the business, at least his argument is, having the license did not necessarily mean that you met the county zoning code. Okay.
That was a permitted use by the county at the time, because when I bought the property, I went down to the county and I said I would like to have a list of all permitted uses and I would like to have a license for everything I'm allowed to do on that property.
Okay,
That's why they issued me every one of these licenses, even some of them are ridiculous that I don't use, and I renew them every year.
Well, let me just stop you with that, though. So I think what you need to present is what was the county code prior to the incorporation of the town, so that we can see whether those uses were legal.
Well, Mr. Breyer, did you meet the zoning code at the time you applied and paid for your licenses?
Yes, sir.
And is the variety store that you're now operating, was it a permitted use under the zoning code?
It was, sir.
And did you take a look personally at the various permitted uses within the code?
I did,
And is your use of it within those permitted uses?
100%.
Did you have occasion to ever renew that license?
Every single year.
Could I have the next renewal, please?
Yes, sir.
And as you're looking for it, have you been licensed by the county continuously since both before the city was annexed and after the city has been annexed?
Yes, I have.
Have you ever been given any citations or any letters or any evidence or any misdemeanors or any pieces of paper from the county which would suggest that you are not legal?
No, sir.
Have you ever heard anything from them orally or in writing that you are not legal?
No, sir.
And have you taken that to mean that you are legal?
Yes, sir.
I interrupted you while you're looking for the next license.
And Mr. Magistrate, while they're looking for the license, I do have Article 75, non-conforming uses, structures, and plots. We'll provide that to you as exhibit number 11, I believe, Madam Clerk. Exhibit number 11.
Do we have a 10? I know we were 9 with this
Was
last
10 submitted, Mike, as the,
10 was, number 10 was the letter from Braden marked up to number 9, so whatever, so we're up to 10.
This one.
I'm sorry, did you submit the legal?
No, haven't done it. No, the case was not evidence.
Number 10, Mr. Magistrate.
Okay.
And at the appropriate time, we will provide you in evidence the county code, so you can see the list of uses and the code provisions that were in place at the time of incorporation, but we'll wait till they conclude to put that in. So, wait a second, number 10 was what?
Non-conforming uses.
Let me just guide you fellows a little bit here. The code says that the use had to be in place as of October 1, 2006. So if you can go back that far.
The town was not incorporated in October 1, 2006.
Yes, it was. I was off by a year.
Okay. But I'm just going to read the code to you. This is section.
Well, that's still,
That's the code.
This is the
for
code.
for grandfather.
The code is, this is section 75035. It says, certain uses that were in existence as of October 1, 2006 are not contained in table permitted uses, but may be allowed to continue to use subject to the following, and then there's more. But it says the applicant shall have the burden to demonstrate that the use was in existence as of October 1, 2006.
it was in existence, and I went to the town council meeting and the special magistrate, the town council hearings in 2008, and they agreed that I was licensed, and that's the whole reason they said that they were setting up their ULDC, which is the Unified Land Development Code, and if I changed my vote in order to vote for the not the college, but the property that is south of me and the property that is east of me, for them to go for commercial zoning, that I would not have any problems because they would include that in their ULDCs, which they just formed a new committee for the ULDCs, Unified Land Development Committees, and they allowed the gentleman who filed the complaint, who's my competition and the owner of Red Barn, to become a member of the committee for the ULDCs.
We're going to check this relevance.
That's a lot of relevance.
It's a lot of relevance.
It's a lot of relevance, okay? That should not be allowed. He has filed against Janet Ike. He has against British Hay Company. He has filed against every single person in this town that opens up a feed and hay business. So now he's on the committee to stop them, for anyone else from ever filing or opening a business. There's tons of relevance there, Mike.
Well, don't get personal, Mr. Breyer.
It's nothing personal, just business.
Excuse me, let me second that. Try not to get personal.
Okay.
Has your use as a variety store remained the same since before 10/1/06?
I'm not sure of that exact date, Jeff.
Do you have an understanding about whether you're allowed to get a county license if it is not pursuant to the zoning code of Palm Beach County?
No, they will not issue it.
And were you aware of that understanding when you went there seeking and paying for a license?
100%.
And did you speak to them about a variety store?
I did.
And did they tell you whether it was a permitted use?
It was.
Are you still looking for your next permit?
Yes. I need some time. I have several files here.
They Tom, they have, I'm sure, unending time here.
Can I address the code section?
Yeah, well,
we were looking at? The code section you're looking at, I don't have the site in front of me, but it has three kind of steps. If it's legal before and it's legal now, okay, that's not included in that code, because clearly under the town's code, it's legal use. If it was legal under the county's code, then it's deemed to be legal non-conforming use. And that's, if you can demonstrate it was legal at the time we incorporated, that use can continue as a legal non-conforming use. That's grandfathered. The last part we read about was that the council wanted to provide an opportunity for folks who could not prove for whatever reason they were legal, whether it be a paperwork issue or documentation issue, whatever. There was a process that was temporarily open when they adopted ULDC, said if you could show, you had the burden to show you were in existence as of the date of incorporation. You didn't have to show you were legal, but in that case, you had 6 months to come in and file for a special exception use. Those 6 months have expired. And even so, you would still have to come to the town council to create a lawful use by going through the special exception process. That hasn't happened either. So that section of the code that looks to that date, October 1st, 2006, is irrelevant to what we're doing here. So the issue we have this morning is whether it was legal under the county code at the time of incorporation, which therefore would be in its grandfather. And at the appropriate time, we'll provide you a copy of the county code that was in place, and then you can weigh that against Mr. Breyer's testimony that it was legal because the code reflects it.
And I'd also request that all the minutes from the meetings for 2008, when we first went into the first violation that the town council got rid of, I would like to have those exact minutes so I can provide those as evidence to your honor.
He's looking for that. We're going to move into evidence the meeting from last Thursday. Does anybody have that where we can put it up here, or do we need to use a computer?
We'll have to get a computer that has access to the internet, and we'll have to hook it up so that it can be seen on the projector. So we'll have to take a little break.
Would, I don't know if there's anything we can address here. We can take, a couple of minute break here and let you find what you need. But again, the date is the October date, I guess, and we can go from there. Why don't we break for 5
We're going
minutes?
to try to show the last Thursdays, if you could help us with
It's
that.
on YouTube, but we'll have to access the internet. Which
Well, I understand. Whatever you can do, or wherever I can do that.
I have an iPad, we can't do the internet, we can connect to that. Okay.
She has an iPad and a card. Does that help?
Can we connect to an iPad with internet?
You can use this here. These ones.
And then we have to set it up to the projector.
Do we?
Yeah, why don't we take a 5-10 minute break to let Mr. Breyer look for his stuff and also to see if we can get the technology set here for the.
Okay. Thank you.
You are technical assistant?
And then you have the password?
I'm in, yeah.
You're connected. She produced this. You welcome.
That's okay now.
Oh, yeah, should I hit the recorder too?
You can see anything
Okay.
Your Honor, we have a modified, what I think is now a request as opposed to a stipulation. And
We're back on the record, right?
Or here, I think.
Thank you.
And that is that the respondent seek to continue the balance of his presentation for 2 weeks in the interest of judicial economy for this reason. We have already spoken our prior request for the effect of retaining the land planner, which has been stipulated to, providing a letter to the city, which has been stipulated to, by the end of next week, that he is retained and requests a meeting with the city. That all of that be done to the city by the end of next week. The request is now for a 2-week continuance, because if that happens, it may make these proceedings ultimately moot or moot at that time. He has documents to produce. He has 2 town hall meetings to either seek judicial notice of, or to the extent the website has it, present to the court. The city, as I understand it, is okay with that plan, but what they are not okay with is our continuing our presentation in 2 weeks. Is that fair so far?
You lost me at the last point here. The town is okay with what part of it,
Well,
if any?
well, we're not okay with continuing, okay, because we have presented our case. They've had an opportunity to present theirs, they know about it, the hearing, they can continue to present their case. I've raised my objection before to the documentation, and Your Honor has accepted the document for whatever weight you want to give it. But the town feels it's important to bring this matter to conclusion and get an order from you one way or the other. And so I'm not authorized to agree to any continuance. They've started their case. If we need to be here while they finish their case, we can be here while they finish their case. We'll present the rebuttal and we'll be done. Don't know how long that'll take. It would appear that it would take quite some time though, but we're ready to proceed.
Okay, so there's no agreement on the 2 weeks. I was sort of getting the feel that you were okay with 2 weeks.
Well, I really don't want to go into discussions, but.
No, I'm not asking your discussion. You don't agree to it.
We don't agree to the request.
Okay.
And I'm not saying that you'd be inclined or that weighs anything that I just said, but either way, definitely 30 days, this is way too long for what's been represented. 2 weeks would have been more in line, but again, that would only be if we had agreed to not finish today, which we would like to do. But again, it's got to be left with your discretion. We just would not accept. We would think it would be inexcusable to go beyond 2 weeks.
And there's one more thing I had offered, and that is to allow them to present to the court the county's response to the licenses they've issued. And that was done in an effort to put the issue in front of the court, and I still would stipulate that you can put that in now, before I ask for my 2-week continuance to finish my defense. I agree with that.
We can provide the documentation, and then you can decide whether you want to proceed forward or schedule a time.
Well, I'm not, we sort of went through this once with continuance. I'm not inclined to continue it. We're in the middle of the case. In the middle of the respondent's case. So I'm going to deny the request to continue again. And I think we need the rest of one thing I had a chance to read the town code while we were taking a break, and I think the section we're under 75-010, does that sound correct? Uses and structures existing as of October 1, 2006. The date's consistent with what I had mentioned in 75-035, but that does apply to something else. So it seemed that 75-010 would be the applicable section as far as non-conforming uses and how they're proven and the effect. So I just wanted to clarify that. Anything else we need to address? Were you able to find your licenses?
I have several licenses, Your Honor.
Okay. Were you able to
And
find?
also the one that you have is a renewal, so there's another one prior to that I have someone at the county trying to get as we speak.
Okay. So when I asked you if you found them, you have, I know you testified you had them, but you have them with you.
Do I have them with me?
Yes.
Mr. Downey, we'll stipulate he has occupational licenses and mobile business tax receipts from the county. I mean, it's clear he does. It doesn't change the legal analysis, and that's why I objected before, but we'll stipulate that he's got local business tax receipts dating back to whatever year he wants, prior to 2006, which is a relevant time frame, and continuing after by from Palm Beach County, because we've already agreed on the record not to come from the town itself. So I don't know if that will help expedite their case, but I'll stipulate that the town will stipulate that they have local business tax receipts or when they were called occupational licenses dating back before October 1, 2006.
When did you open it or first start operating this property?
I bought the property, I believe in September of '04, and I probably started operating in '06, I believe, that it would have been '05 or '06, I'm not sure the exact date, Your Honor, I'd have to check on that, but when I bought the property in '04 is when I started going to the county, and I bought every license that I was allowed to have it on the property.
Okay, well, that, with that stipulation, I don't think we need to worry about that issue. What all else do you want to present?
I'd like to present the town council meeting of last Thursday night, and the videotape, as I understand it, is available.
It was not a town council meeting, it was a town workshop meeting.
That's the one. We move that into evidence and ask Your Honor to review it.
Okay, just so I have something in my notes here. The town workshop, when did it occur?
February 14th.
Can we start at the beginning, please?
How long was the workshop?
2 hours.
We're not watching. I object to a 2-hour video.
Yeah, there has to be something you want me to see out of there other than 2 hours or something.
Well, I will proffer it in its entirety, and then the court can make its ruling and watch what the court wishes to watch. I proffer the entire meeting. I believe it's 9:14.
There was a reference to, I guess, was it town planner, Mr. Flashman? I mean, is that what you want me to see? I mean, I don't think it serves anybody to sit here for 2 hours and watch probably a lot of stuff that's not relevant.
That's the reason for my request to continue this choice.
Well,
It has a lot of relevance inside the video of the whole meeting. I was there, I attended on Valentine's Day to make sure why I was attending and spent my Valentine's Day there in order to attend this meeting.
okay.
Your
Well, I
Honor,
understand.
I would not object to, on the record today, showing a portion that discusses the town planner's comments, which I think is what has been represented as relevant to the respondent's case. And then I would not object to you having the ability to review the entirety of the meeting in chambers or whatever you want to call it, and that the entire video be committed into evidence. But I don't think we all need to sit here for 2 hours to put in context what a comment is by the town's planner that the respondents are relying on for their case.
Do we have that, is that acceptable to you guys?
Yes.
Why don't we, if we can find that part where Mr. Fleshman is speaking, why don't we get to that, and then that'll provide...
That's fine, Your Honor, because I understand the stipulation that you will watch it in its entirety at some point before you rule.
Well, my stipulation is it comes in the whole video's in the evidence. You know, I don't want to put him on, he can do what he feels he needs to do to review it, but the whole video is in evidence. Just, you know.
And I'm requesting Your Honor to view it, and that's up to Your Honor. That is a respectful request.
Okay. So I will accept the entire video, and why don't we see if we can watch
We have a number
an
of
excerpt.
full respondents video, exhibits yet?
I think
We
they're
only got
on-
one local business tax receipt
I think
in.
they're on number 2.
You too.
And what we did, just for the record, that Mr. Breyer substituted a copy of the business tax receipt for the original, so he which he wants to keep, so we do have that marked here as part of the record.
Where would you like to start?
I think it might already be very close to.
That's queued 23 minutes, and basically 24 minutes to start.
Maybe you have to go backwards.
Go back?
That's why I said let's review all of it, but you guys don't want to take the time to see the evidence.
I just need a starting point.
I would say 17, 18 minutes would be maybe a starting point.
Starts at 1657, we're starting. This is the loudest of this, what's their fees?
How are we gonna be able to hear that?
I'll check to see if they have a
Should be a way
PA
to get that
system
speaker
that
going.
put on speakers,
Well,
but that's the maximum limit of the.
Why don't we do this, since I'm no doubt gonna have to watch this anyway, why don't you, instead of taking anybody's time here, why don't you proffer to me what you think is pertinent out of that video, and then I'll know what to watch for, and we can see if there's any objection.
We have some technical assistance coming, so.
Oh, thank you.
That's gonna work?
Speaker system here.
I've got the speaker,
We
you
have
have a
the
PA
speakers,
system?
but,
Are the, is the volume up on your?
yes.
It's just the recording actually. Yeah.
Well,
I'll be happy to, Your Honor.
yeah, why don't we do that instead of,
I'll be happy to, Your Honor, and I would suggest that Mr. Breyer will follow up when I finish, but it is to the effect that the agent of Waxahachie Grove, the land planner, Jim Fleischman, has essentially said to the effect that if you were permitted before, you will continue to be permitted, and we're not seeking to change anything that was in existence and permitted in the past, we will continue to be permitted by the city, and we will not hunt down landowners for non-compliance.
okay.
Now, Seth, could you add to that, what, you were there, what Mr. Fleischman said?
I have a computer that works.
No, those usually work pretty well.
Well, I'm gonna watch it, I just need to know where it fits in the context of.
What did Fleischman say?
He specifically said that if you were in existence prior to the town, that whatever you were doing was a permitted use, you can continue doing that use, and the town would not seek to change that.
Okay. Well, let me just make this comment, and I'll maybe hear from Mr. Strillo. That sounds consistent with the town code. I mean, or am I missing something? You're saying that's inconsistent with the town code?
They're saying my use wasn't permitted. That's the whole reason I thought this hearing, what we were here for.
Now, as I read the town code, it says that, and let me go to this section, it says, all uses, and I'll paraphrase, this is section 75-010, all uses, structures, and plots of land that were legal and conforming to the Palm Beach County Land Development, Unified Land Development Code as of October 1, 2006, shall be deemed to be legal and conforming to these regulations. Okay. So,
Okay.
I mean, that's sort of a classic statement of non-conforming use. If you were legal before, you're gonna be a legal non-conforming use, even though maybe the town zoning does not permit.
You're gonna be
what you're
legal
doing.
or illegal? What'd you say? I didn't hear
I
that.
said, if you were legal before,
Yes, sir.
you would be a legal non-conforming use under town provisions. So I don't know that,
Then why are we here?
well, I think the town's position is that their position is you were not legal before. I think that's what they're telling me they're gonna present.
That's correct.
So I mean, it seems that that's where the case is coming down to, that,
Well, I spoke with Jess Santa Maria's office, and he said that he would have someone from his office to come down and testify that that was a legal use and the dates that I had it. They also found prior licenses, because I have so many licenses. They're actually, I called them, and they're actually printing out records of every single license I've ever had in Palm Beach County.
well, I understand the town's already stipulated that you had county licenses.
Okay, so that's what I'm saying. If
They're-
you're saying, if you're, the statement that you just read to me, Your Honor, if you're saying the town is stating that I had county licenses, plus the statement that you just read to me, then I don't understand why we're here.
Well, the town is saying, and they gave me a case to read, and again, correct me if I'm misstating the town's position, They're saying that the issuance of an occupational license or the issuance of a business tax receipt does not make one a legal use.
They're giving you that from 2008, Your Honor. Our licenses date back prior to that.
The date's not the issue, as I understand it.
Well,
That's correct.
The date's not the issue. They're conceding you were there before October 1, 2000.
right, but the paper that they're saying came out way after the licenses, and we have something from the Palm Beach County, okay.
Your Honor, at this point, again, I just say what's relevant is the zoning. and
It's
compliance
subject to
with
zoning, that's what it
They-
said. That the
they-
license is subject to zoning.
That's right, and they would not even issue a license. Here, I'm gonna read you right off of the Palm Beach County website, Your Honor.
I'm familiar with business tax receipts and occupational licenses. And they would typically do a zoning check.
Yes.
I understand that.
Yes, sir. It says, local business tax receipts are issued by the town collector's office for the privilege of operating a business in Palm Beach County. Anyone providing merchandise or services to the public, even a one-person business or a home-based business, must have a local business tax receipt. The Palm Beach County local business tax receipt is in addition to, and in lieu of any license required by law, municipality, list of municipalities, ordinances, and subject to regulations of zoning, health, and other lawful authorities. Business must display the Palm Beach County local tax receipt conspicuously at your place in open view of the public, which mine has been in the same exact spot since I opened.
Okay. And you were reading from the county code, correct?
I am reading from Ann Gannon, Constitutional Tax Collector website.
And I don't object to them reading from the site. Because again, I don't know whatever relevance that is, again, but anyway.
Okay.
Well, if it helps, I will grant them a continuing objection to relevancy as I proceed. Did you understand that when you went and sought an occupational license from the county, that you were subject to the zoning laws?
I didn't even know of that in effect. I asked them what I could do on my property that was legal and what I could be licensed for, and I paid them for a stack of licenses, and I did that every year up until the present.
And did you understand that each application that you were legal and conforming under the Palm Beach County zoning laws?
I assumed I was legal and conforming because every year they renewed the licenses, and I never received any violations from Palm Beach County. I never received anything saying that I had to do anything additional or anything. I just paid every year my renewal fee, and I went down there and I stood in line and I bought my licenses and paid and paid and paid.
And each year, did you believe that you would not have been allowed to get a license had you not been a permitted zoning use?
I had no idea about the zoning uses at that time, but I knew that if they were allowing me to buy my licenses, then everything was okay, because I knew there were several laws that stated once you were in business, you could not retroactively be put out of business.
And you mentioned a gentleman named Mr. Santa Maria.
Yes, Jess Santa Maria, who is the Palm Beach County Commissioner.
Do you know the years when he was the Palm Beach County Commissioner?
I don't know the exact years, but I know that he's been a Palm Beach County Commissioner for several years.
And did you speak to him in his capacity as a commissioner?
I did. I spoke to his office, and I also had people speak on my behalf. Also, when the town of Loxahatchee Groves would not approve me to have a PCA rodeo, which is a Professional Cowboy Association rodeo, because they said it wasn't an equestrian event, but I couldn't find more of an equestrian event than a rodeo. And they wouldn't allow it because I was on a dirt road and not on a paved road. We went to Jess Santa Maria's office, and he overrode the town of Loxahatchee Groves.
I don't know, again, that's how that's relevant to what we're here on today, and I don't even know if that's accurate, but I just object.
It is accurate because you were there and wouldn't issue the special use permit, Mike.
And I object to him getting personal, I'm just trying to, you know, I'm just trying to present a case.
I would again caution you, please don't get personal.
Okay.
What did Mr. Santa Maria's office, he or his office as commissioner, say to you about your legality or illegality of the uses of the variety store?
There was never an issue of the variety store. I was always permitted to do it under Palm Beach County and should be able to still do it today.
Were you ever held up in any of your licenses or denied a renewal?
Never.
Did you have any contact and interaction with the city after it was annexed in either the years 2008 or 2009?
I did, 2008, I believe.
Please tell His Honor how the city came to get into your life.
The city, well, Beck Islop, the owner of Red Barn, who presented testimony at one of our prior hearings here, who stated that he didn't mind competition, that he just wanted it to be a level playing field, if I remember his exact words. And his level playing field was that if he's paying commercial taxes, commercial agricultural taxes, that I should have to pay them. That's when the whole issue came up with the city for us to file a land use change. There's also several violations that stipulate on his property how many trailers he's allowed to have, and there's a lot of laws that he's in violation of that I have not filed a complaint against them. So we're trying to make it a level playing field, and it's just the same thing, Your Honor. We asked you for a continuance to hire a land planner. The town went outside, spoke to my attorney, and said they would give him 2 weeks. Okay?
We're
And
trying to
that's right.
I will join in that objection.
We need to, in order to protect the sanctity of our discussions.
So any discussions outside the room should not be.
Let's return.
Well, I'm not an attorney, so I don't know all these things.
That's why we're helping you. Let's return to 2008 and 2009. Did you attend hearings and meetings with the city after they were annexed about your uses of the variety store and other permitted uses?
Yes, and they were dismissed. That's why I don't know why we're here again in 2012 because of a complaint in 2011. The way I always understood the law is if you had charges filed against you and they were dismissed, in order to file them again would be called double jeopardy, is the way as a layman I understand it.
Back to 2008, was there any findings of illegality or anything wrong with the uses of your property?
No.
And at that time, were you using a variety store at that time?
Yes, sir.
And did you advise them of that use, and did they find you in any violation?
No, sir.
And has your use changed in any way since those hearings before the city after they were annexed?
No, sir.
Your Honor, we'd ask the court to take judicial notice of the minutes of those meetings since the beginning of the town's annexation up to and through the hearings involving this particular property.
The only comment I have on that is that I don't understand which minutes.
Yeah, I can't take notice of all the minutes for everything.
I would not object to, if he's got specific dates that he wants to identify, to put in, or, in that respect, but and plus judicial notice, it doesn't need to be judicial notice, they're public records. If he had them and gets them from the clerk's office or some other verifiable source, I'm not going to object. And he doesn't need to make a formal request for judicial notice. I just think we need to know the dates of the meetings because
You as a town issued the violation, you guys as a town issued the violation. So you should be able to look at the dates of 2008 that you issued the violation. You should be able to look at the dates of the hearing
I'd be
for
happy
the
to-
town council and provide us with those dates as well. That's what they call disclosure. I thought you had to give us what you have, and we have to give you what you have. I saw that on a movie once.
Well, one of the documents that Mr. Brown referenced, which I was going to put in, Mr. Byer just suggested that we do, is the records from the original notice of hearing back in '09. I was going to put that in. Mr. Brown had indicated he wasn't going to reject, and maybe since it's come up now, go ahead and put that in as the town's number 11. It has the notice of violation. It also has the county code that was in effect as of that time.
Well, what you have from '09, you want to submit one thing, but what about the stuff from '08?
You guys, you can, I'm just gonna move in, you know, unless you wanna do it at the end, but.
I would rather do it all together, not have one out of context.
You were here, okay, I'm not, you know, anyway,
Yeah, we'll hold off on your,
That's fine.
until we'll let them,
that's fine. I apologize.
For your honor, let me give you the dates of a notice of violation, January 14th, 2009, a notice of violation, March 28th, 2009, and a possible hearing date of May 21st, 2009.
That was canceled.
And that's what these documents are, and again, that's why I was gonna suggest is putting it in at this point. Those dates mesh with what he just put on the record, and this verifies that timeline.
I have no objection to them introducing it out of turn, if your honor.
Yeah, why don't we do that?
It would be the town's number 11.
And may I add something in terms of,
Well, wait.
okay.
Okay.
No objection.
So we will admit into evidence Town's Exhibit 11, being a, it's a certified copy of a notice of hearing dated April 28, 2009, notice of hearing March 12, 2009, notice of violation dated January 14, 2009.
Okay, Your Honor, at that time, we had went to the town council with the same licenses that we are coming here today, and they canceled those hearings, and they saw all of our licenses that dated back prior to it becoming a town. So, I've already paid legal fees and done this already once, and now we're here a second time for the exact same thing.
Can I suggest something when it comes to the minutes? Why don't we do this? I mean, I'm willing to allow the record to be, you know, supplemented after conclusion before you render an order. I can work with Mr. Brown, and they can identify the minutes that they want to present, and once that's identified, I can do it just like we would here, and he can file it at that time. I just ask that that be done in short order within, like I said, the next week. And if that's acceptable to Mr. Brown.
Week is very short for the amount of hearings and meetings that Mr. Brown attended that I paid for already.
Anyway, that's,
I mean, there was
I'm
several
offering that.
meetings.
I'm offering that. So that way we can get the proper minutes in that they don't have with them present today, that they could have had present clearly. But I'm offering to accommodate them. I just want a really short turnaround on any supplemental files should we conclude this hearing today. That's all. And if that offer's not good enough, then I would object to any further supplements of the record because we had notice of this hearing for at least a month, and in this case for months. So I think that's a fair offer to allow them to provide the minutes that they feel is important. And so I want a quick turnaround on it, that's all I ask.
Your fair offer is accepted.
So,
Yeah, I would think that's fair as well, and so we will, when and if we get through this, we will leave a week to submit those minutes.
minutes of whatever town council, workshop, meetings, whatever they feel is relevant, as long as I can see them ahead of time and verify that they are the minutes, that I'll work with Mr. Brown.
You're gonna get the minutes, and then I'm gonna respond.
Well, you can give me the dates. I'm not gonna go looking for the minutes for you.
Can we have the dates as far as from our first violation? to every hearing that we had with the town council?
All I'm offering is to allow you the opportunity to get the minutes that you want.
Okay, who can I sit down with in order to get the accurate dates for Mr. Brown?
We can talk about the logistics afterwards. All I'm offering is that if you feel there's minutes that you felt was important, that you don't have today, I'm willing to allow you to get those minutes and to file them with the magistrate. I think that's, I'm not gonna identify it, we're not gonna go do word searches, that's not our responsibility, candidly. Mr.
Well, can
Brown,
I
if
pay
you would
someone
agree
to get me copies of those, the town clerk or something?
So, anyway,
You're gonna have to handle this outside the meeting.
Right.
Or the hearing.
but I'll even give them till a week from Friday, which gives them almost 10 days. I think that's fair.
Thank you.
That would be what date?
That would be the 21st, March 1st. And that's a supplement with any minutes of town council meetings that they feel is relevant. And I would even, if they feel it's relevant, and they come, and they're off their minutes, again, I have my standing objection to relevance on local business taxes and whatnot, and I can address what I think those minutes say in closing if we get there today.
The result, may I proceed? The result of those hearings and those notice of violations, was there ever a finding of any violation of anything?
No, sir.
Have you ever been told you have any unpermitted uses on your property other than the subject action?
After the 2008 and 2009 violations, everything went away after the town council meeting because I was specifically told by the town council that the property that was surrounding me was going for what they call a large-scale land use change, and you had to be over X amount of acres in order to do that. And I had to wait for them to finish, and then I could do what they call a small-scale land use, and they would pave the way, and I could ride on their coattails if I could remember the exact verbiage.
And after those notice of violations in 2008 and 2009, did you work with the city and come to an agreement that you could continue to do those things that you are presently doing?
They told me that my property would be in the new ULDC, Unified Land Development Code, as per the licenses that I submitted to the city at that time.
And at that time, back in 2008 and 2009, did they allow you to continue to operate the variety store as you had been operating?
Yes, sir.
Have you done anything different to operate your variety store since that understanding with the city?
No, sir.
Your Honor, we may or may not be either finished or soon finished. We're also at the lunch break. Would you like to proceed and conclude before breaking? Or would you like to?
How much, what's everybody's preference? Do you have, you're gonna have some rebuttal?
I would suspect ours would be about 10 or 15 minutes at most, including argument.
Yeah, I'd just soon finish if that's the case.
Oh, I have a lot more to present, Joe.
That's what I'm asking, given the.
Well, yeah, I have a lot more to present. There's nothing concluding.
Excuse me, I'm sorry, but I think we're we're the next case to be heard, and this started at 10 o'clock, and we have an appointment in North Palm Beach at 2 o'clock that we have to be at. I understand there's a lunch break now, but I didn't know there was going to be.
Well, there may or may not be.
Okay, all right.
Of course, we don't know how long this case is going to take. Why don't we, for now, just keep continuing, and we'll talk about lunch in a little while.
All righty, you have some other things for His Honor. Please continue with your defense.
Well, specifically, I would like the people here to be able to view that video. I don't understand why we can't do that.
Because I'm going to do it on my own.
You're going to do it on your own, but how does that become a matter of public record if we're on recording and for the benefit of witnesses and everything else that's here now, Your Honor?
The video is admitted in evidence and will be part of the record.
It'll be part of the record, okay. I would like to call Mayor Browning as a witness as well. I would like to call Ryan Liang and,
Are they here?
pardon?
Are they here?
I don't see them in the room.
Well, if you need them here to testify, you need to get a subpoena on them or somehow get them here. I can't beam them in.
Okay, so can we do something like that?
No?
How do we get them?
Do you have anything for His Honor?
I have lots of things that they stated to me.
Tell His Honor what they stated to you.
Mayor Browning told me that once everything was...
Just for the record, I would object, but I know hearsay is admissible, but I would object probably, I have to see what he says, I don't mind the proper, but most likely it's irrelevant, but I can explain that later. I just wanted on the object that if he's going to relay conversations he had with the towns like this.
That's why I would like to request him to be here.
Anyway, that's on the record.
Tell His Honor, I'm sorry, Michael.
You go ahead and tell me what the mayor told you.
That once all the property that surrounded my property was complete with their, they had to do postings and signage and all that in order to get these land use changes. That the town council would then go ahead and approve our property because we would be completely surrounded as a horseshoe by commercial.
Let me just stop you there. Has that happened for the other properties? Did they get...
I believe they can answer better than I can if they got their approvals or not.
I will stipulate that the L-shaped property on the east side of B Road, other than Mr. Breyer's property, has land use in place, mixed land use. We have this comprehensive plan. The properties to the west of B Road is an inverted L, upside down. The inverted L, which the top part corresponds with Mr. Breyer's property, is actually back to RR5 because that's the State College property. The lower property on the west side of B Road is, I believe, continues to be MLU. No, a commercial. CL, excuse me. So, and to the north of Mr. Breyer's property is collecting canal.
Is there a map we could look at to explain what you're talking about, please?
I do not have a map, but I would
Is
stipulate that what.
Is this one that was provided by your
I
office?
would ask Mr. Brown if he wants to take a look at it. I'd be happy to take a look. If that's
Okay.
accurate, I would have no objection.
Thank you.
Well, it doesn't show the current land use, but it is a map of the town.
But is it specifically those white boxes, my property, or no?
The three, oh, I see what you're saying.
Yeah.
Yeah, I believe what he's saying is, those three there is, this is the MLU around it, and this is the State College. Okay, that's what you're getting at, Mr. Breyer? Those three are yours, this horizontal is the MLU, and then across the street, B Road, that's the State College property. That's what you're doing.
Where's connecting canal, Mike?
Isn't it 6-4, isn't it right here? Isn't that the one 6-4?
I thought I was over here, that's why I
Do
was
I have it
asking.
upside down? No, I don't have it upside down.
Maybe I do.
You're right here.
Okay,
Okay?
so then connecting
Connecting
canal?
canal is right here. This is southern.
Okay,
Okay? This is B.
okay,
These three are yours,
okay.
right?
So this is where the college is going, correct?
This is where the
And
MLU.
this is where the MLU is?
That's correct.
Okay,
Is that what you want the map for?
yes.
No, you want to put it in, Mr. Brown?
I don't have any copies of it, that's my only copy.
We'll make a copy. But I don't object.
We'll move that in as respondents three.
Let me just show the magistrate, we'll have a copy made before.
Can you explain to him what you just did me, so he understands?
You don't
please?
mind?
No, sir.
Okay. So those three properties there, and Mr. Best's property in question. The hash mark is where the MOU is.
You know you mean what?
Multiple land use designation is gonna have commercial low, and institutional, thank you. This parcel here is all what's called the State College parcel. And this isn't currently the way it's mapped out here, but this is R5 with a commercial down alongside. And I think this is demonstrative, so he can show you his property in relation to others in the area.
And to the north, that's
And I don't
canal,
object to it.
canal to the north of this
Canal,
property, right?
Viking Canal is right there.
And then to the north of that is what kind of zone?
Well, it's AR land use, and it's, RR5, right? RR5. So, can you make a copy real quick?
Sure.
Okay, thank you. All right.
Mr. Sorello, may I ask you one question? Can you tell me what this document is, off the record? I just know it's got his signature on it and stuff like that. Is this part of it? Is this from the hearings in LA, or?
Okay. Might I explain?
You might?
This is ordinance 2011, all it did was change the permitted uses so that mobile homes could be allowed with a special exception. Okay,
So this really has no relevance?
Well, it's up to you. I would say no, but it's up to you.
Okay. Thank you. There was a town council meeting on July 15th of 2010. I believe the town council public hearing was July 20th of 2010. That's when these maps and the codes were talked about, and also when my charges were like dismissed. So,
Well, I would suspect you'd want to present those minutes to me.
well, he gave us the opportunity to get all the minutes till next Friday, I believe.
I understand that, I'm just saying that would be some of the minutes you should be part of them.
Okay. What has to be done for me to call these witnesses, Your Honor?
Well, you would need to have a subpoena issued and have them here today, which is a little late. I mean, we're here for the hearing, we can't.
Well, but we're only here for the hearing based on what I thought was going to be a continuance based on your order by me turning in the land use packet and the cashier's check for $7,500.
Okay. Well,
And also, we're receiving receipts from the town of Loxahatchee Groves with the dates Well, Your Honor requested I do it in a timely fashion by February 15th.
Well, we're not continued though, and we're having the hearing, so whatever you need to present at the hearing needs to be presented. My intention is to finish this today, and
Well, but my intention is to have time to call these witnesses that I thought if I agreed, if I did what you asked me to do, by the time frame that you asked me to do it, that this would be continued. So I didn't have my attorney subpoena these witnesses, and I need them here on my behalf.
well, they're not here. I mean, all he does, they're not here, and we need to move on to the hearing, so.
And I can just put on the record, you know, what we're talking about is whether this with these uses were legal under the county code. And the opinions of elected officials doesn't affect what the code says. And there's the Moretzky versus Florida by the Sea case is a perfect example of that, in which a town council approved a variance inconsistent with its own code of ordinances, and ultimately the property owner was required to remove that wall because not even the town council can deviate from its own code. So whether an elected official says, oh yeah, that meets code, or it doesn't meet code, the code is adopted by the council as a whole, and individual comments are irrelevant, and any inconsistent actions, even by a council, is irrelevant.
Okay,
I
but
would reserve.
And I'm just citing
For
Moretzky.
final judgment, I'll be asking the court to allow us to file written closing arguments.
Well, we can get to that, but I need you to focus on the issues of, your burden is to prove that you had a legal non-conforming use as of October 1.
they already admitted that I did.
They haven't. So whatever you want to present along those lines, I'm happy to hear it, but otherwise, I mean, calling or trying to call as a witness somebody who's not here is not going to work. We can't. We've got to move on with the hearing.
Well, I would have done things differently if your exact words to me last hearing, Your Honor, were by February 15th, which is the Friday before the hearing, make sure you turn in the application and you pay the $7,500.
We've been through that.
I know, but how come you're not honoring your own word?
Let me ask a couple questions. So as to complying with the last court order, did you come to City Hall last Friday?
Yes, sir.
Did you bring a check? Is it in your left hand?
Yes, sir.
Your Honor, I'd move that into evidence as respondents for.
So the application's coming in.
First is the check.
I would just ask him to confirm whether the check was left with the town, or whether he took the check and left a copy of the check with the town.
I'll do exactly that.
Mark
Hold
told
on,
me to...
excuse me.
Okay.
Please listen to me sometimes. Did you bring that check, which I'm asking to be respondents for, did you bring that to the city?
100%.
And were you intending that they would take it from your hand and put it into their bank?
Yes, sir.
And did you tender it to them to put into their bank?
Yes, sir.
And what was their response?
Mark said that we have to go through all this. It's Friday afternoon. It's 3 o'clock. We're closed Monday. We'll call you Tuesday. We'll issue a receipt with today's date for $7,500, which is in my right hand, and we'll take a copy of the check. We'll call you on Tuesday after we speak to Mike Cirillo and he speaks to Jeff Brown, and we will tell you to bring the check back up here.
And did you hand him the check?
They handed it back. They made a photocopy of it and handed it back to me.
First of all, it's in your possession when you walk through the front.
Yes, I did hand them the
Did you
check.
hand them the check?
You're 100%.
Did they make a copy?
Yes, sir.
Did they hand the check back?
Yes, sir.
And did you therefore take it back along with the receipt they gave you?
Yes, sir.
Along with the check, did you submit an application?
Yes, sir.
Was it signed?
Yes, sir.
Was it notarized?
20 different times.
Did they take it from you?
Yes, sir. They have the original.
And what do you have in your now writing?
A copy that I also have a receipt that I paid the nice lady at the town to make photocopies of. She made photocopies of the entire packet, and I got a receipt for photocopies.
Remove the application, which is now in the possession of the city as respondents filed. That's that check.
Okay, so the check will be 4 and the application 5?
Yes,
I'm guessing here, the relevance dates back to your decision whether to continue this matter?
There is, I will be next talking about cooperation with the city, but it is our position that having complied with the court order, paragraph 1, that today would have been continued by the agreement of parties, and that he was under a reasonable belief Friday afternoon that he had complied, allowing with a federal holiday of Monday to have made it difficult to have asked me to subpoena the people that he claims to have asked me to subpoena, and therefore that is part for the record of our request that today not continue in light of his compliance with the last court order.
Okay, I will admit into evidence the check in the application is 4 and 5, but the ruling has been made on the continuance, so
I'm aware of that.
so we need to move along.
I was. He was asking me why I'm doing something, and I thought I'd answer his question. That you at all times cooperated with the city.
Yes.
I'm going to show you what's been marked as Exhibit 5 from the last hearing, and ask you if you would read into the record the violation, which is number 1 there.
Non-permitted use located in agricultural residential zoning district. Property is being used for retail/commercial activity.
And have you violated that allegation? Are you guilty of that violation?
No, sir,
And why is that?
because I've been performing the same business for many years, and I have not changed my business, and I've been licensed to do so, and I had this exact same charge in 2008, and we went up against the town council, and they agreed at that time my licenses were sufficient.
And since that time, have you had any discussion with members of the city about that particular violation?
No, the 2008 violation?
No, this one here.
The 2012? Yes.
And who have you talked to, and what have you said, and what have they said?
I've talked to Mark, I've talked to Brandon, I've attended meetings with you at Mike Cirillo's office, I talked to Russ Elgin, I talked to, I'm sorry, I'm bad with names, Beverly, and I've tried to cooperate with every single one.
Have you told them of your discussions with the county and your compliance with county codes?
Yes.
And have any of them ever suggested that you were in violation of a Palm Beach County code?
No.
Have any of them ever suggested that you're in violation of Palm Beach County zoning ordinance?
No.
Do you have anything else you'd like to advise His Honor before I call your next witness?
Just that, at the last hearing, I tried to do everything you told me I needed to do, Your Honor.
Is there any cross-examination?
I'm just asking whether he's got any documentation to show a conditional use or special exception from Palm Beach County for any of the uses on the property. Do you have any documentation relating to a special exception on the property from Palm Beach County?
There was not one required because it was a permitted use by Palm Beach County. That's what the licenses are for. That's what I paid,
Your Honor,
that's what I paid $30,000 over 10 years for, Mike. Mr. Cirillo, excuse me?
Okay. I don't have anything.
Okay.
And not from Mr. Breyer. I understand maybe they've got another witness.
Okay. Do we have another witness?
So who's next call, Mark?
Are you calling Mark?
Yes.
Go ahead.
You may not have known you were going to testify, so you may not have been sworn in.
I'm sworn.
All right. You state your name for His Honor.
Mark A. Cotton?
And has Mr. Breyer told you of his county licenses?
Yes.
And did you check with the county?
Yes.
And did you find any violations issued by the county against Mr. Breyer, Ms. Smiley, or the property in question?
Not violations.
And have you searched the file for violations?
Not personally,
Have you had someone else do it, and have you had the results?
yes,
And the results are no violations?
no violations,
Did you understand that they issued him county licenses?
yes,
And did you understand that those licenses predated the existence of your city?
yes,
And have they been continuously licensed since the birth of your city?
yes,
Is the city under a moratorium?
yeah, for land use applications, yes.
Can you tell His Honor about the moratorium?
The moratorium was put in place roughly in June of 2012 relative to land use applications to provide the staff with time to come up with policy language and associated amendments related to the comprehensive plan for Okeechobee Boulevard, Southern Boulevard, and all matters in association therewith.
And is this a lengthy process?
Yes, it is.
Is that the reason for the moratorium?
Yes, it is.
And has Mr. Breyer or Ms. Smiley asked you for similar timeframes within which to handle the lengthy process of cooperating with your newly birthed city?
I don't understand the question. Can you phrase it?
Has Mr. Breyer or Ms. Smiley asked for similar cooperation as it relates to the lengthy process of cooperating with your city?
Relative to a plan amendment?
Relative to the use, the permitted use and conformity of his property to your newly birthed city?
I've had some conversations with Mr. Breyer that touch and go around that. I've never spoken with Mrs. Smiley.
And did he bring you a check and an application Friday?
Yes, he did.
Did you accept the application but not the check?
We accepted the application. We were prepared to accept the check, except that he indicated he was not going to leave the check with us. And so therefore, we indicated that's fine if that was his intended action, and we made a copy of the check.
Are you willing to accept his tender of the check today?
Yes.
And have you spoken to the county about Mr. Breyer and his licenses?
No.
Have you seen documents from the county as to Mr. Breyer and Ms. Smiley or their licenses?
Yes.
And from that documentation, is it clear to you that they granted him year after year of county licenses?
It is clear that they granted licenses, and it is also clear that they have some concern relative to the validity of those licenses that were issued.
And is there concern that the county may have made a mistake?
Yes.
Did they ever indicate that Ms. Smiley or Mr. Breyer or the property owners ever made a mistake?
I'm not aware of them making that statement.
So is it possible that the county may have made an error?
It is possible, yes.
Is any of that error, by anybody's suggestion, attributable to Mr. Breyer, Ms. Smiley, or the land?
I would say it's incumbent upon Palm Beach County, and not Mr. Breyer.
Anyone else will check the legal conclusion, but go ahead, Nancy.
Has the county ever suggested that there is any fault attributed to Mr. Breyer, Ms. Smiley, the land, or the landowners?
Not that I'm aware of.
And has Mr. Breyer and Ms. Smiley, to your knowledge, relied on those occupational licenses in their dealings with you?
I think it's very clear that Mr. Breyer has relied on those licenses. Yes. And he has indicated that to me.
Did you ever provide to him the documents that you got from the county which may indicate that the county made a mistake?
No.
To your knowledge, was Mr. Breyer and Ms. Smiley ever told by you or anyone in the city that maybe someone else made a mistake so as to allow them a permitted use?
I can't answer that question.
Would he be reasonable in relying on the county to have issued him licenses, though mistaken?
I think Jack, legal conclusion doesn't know his mind.
Yeah, I would say that's speculation.
Well, why don't you speculate and speculate for us and tell us what you think your speculation leads you
I
to?
will renew my objection.
I don't think we want to do speculation.
And I will proffer, Your Honor.
I'm not object to the proper. How does he know what he thinks?
Yeah. No. Good. Go ahead. Next question.
Are you denying my ability to proffer?
Well, you know, you can proffer for appellate purposes, but you
Yeah, if
can't
you want
proffer
to do
for
that,
evidentiary
tell it,
purposes.
but, yeah.
I understand. Please give us what you consider respectful to.
Well, I thought he was going to proffer. That's not a proffer, that's the question.
and proffering his answer. For the record.
Go ahead and answer.
Okay, explain to me what you're asking.
I sustain the objection and speculation, but you can go ahead and answer for purposes
Okay,
of.
can you ask the question again? I'm sorry.
Would Mr. Breyer and Ms. Smiley be reasonable in relying on the county to give him a license, though it may have been mistakenly issued as a result of the county's fault?
I would say that any person applying for a license, it would be reasonable for them to assume that the government agency is giving them the proper license.
And is it also reasonable to assume that if he's not been cited with any violations, that he's not committed any violations?
No,
Same objection.
You can answer.
I would not agree with that.
He should have known he was not using a permitted use, even though no one ever told him it was unpermitted?
And I object again, that's what the Ammons case says. The Ammons case is law on this, he's asking for a legal conclusion.
You can answer that, not knowing you're not an attorney. Go ahead and answer to the best of your knowledge.
I would say, in response to your question, if Mr. Breyer had been informed that that was all he needed, then that would be a logical assumption on his part. However, I'm not aware of the fact that he was told that.
Now, I know it's difficult to prove a negative, but are you aware of any violations submitted by any municipality, any city, any county, or any state against Mr. Breyer or Ms. Smiley as it relates to the subject property?
No, I'm not.
Except ours.
Except the subject violation, that's accurate. Sorry. Have you found in your search any violations anywhere?
On this property?
Yes. That's all I have.
Ross?
Well, Mr. Cutney, you did review records that came from the county relating to occupational licenses or local business tax receipts.
Yes.
Do those records indicate any errors by the county?
Yes.
And do you know what those errors were?
It appeared that they had given, if I'm remembering the document correctly, they indicated that the hay sales was not appropriate in the district. I think it's I have to see the document.
Well, I was going to ask to show you a document, and if you could recognize this document.
Yes, and it reads the occupational.
What is that document?
That document is a document from the county relative to the application.
And do you know how you came into the possession of that document?
Yes, our staff did some research relative to in preparing for the case.
And your staff, meaning?
Brittany Garrett.
Okay. And what does that document say?
It indicates that the application name was for a hay feed and tax sales, and the request indicates under the request line that the occupational license was signed in error is hay feed and tax sales AGUs.
Okay.
I didn't hear the last two words you said.
AGUs.
Okay.
I'd like to have a copy of that.
Well, I was going to ask to move this, bring this into evidence. It's one of the documents that I showed you before from the county.
I have no objection. Can you later get me a copy?
Absolutely. In fact, what I'll do is I've got, if you want to speed it, I've got 2 emails that say the same things from the county, which we showed you before. Do you object to those coming in?
I do not.
Okay, so what I can do, if that's okay, I will move them into evidence, and I will explain what they are, and we can have our clerk make copies real fast.
Okay.
When you're walking up, can I just walk down to the witness on those documents?
Do you want me to, does he need them?
Probably not. You sought those documents from the county because you had been told by Mr. Breyer and Ms. Smiley that they had permitted uses and county permission?
We had done that as part of our due diligence in terms of preparing for the case.
And the due diligence led you to conclude that the county had given him licenses for hay sales and tax sales.
As it indicated on his face.
And the face of the document indicated that that would be what he would be selling in his various capacities, including his variety store.
Well, that's reading a little more into it, but okay.
You know what, he's watching your report diary, and he's looking at documents, Jeff.
I'm
So,
sorry.
I know we want to
Yeah,
get it along, but I just want for the record, number 12 is the computer printout, number 13 is an email dated December 12, 2008, and number 14 would be an email dated December 11, 2008. So now I'll copy.
from your due diligence, were you able to conclude that Mr. Breyer or Ms. Smiley had told the county that he was going to do exactly which he's now being found in violation of by your city?
I was talking to him, he asked him that again, it's my apology, I apologize.
Absolutely. And from your due diligence with the county, were you able to verify that he specifically, or Ms. Smiley specifically told the county what he would be doing in the variety store that you're now violating him for?
From that due diligence, I'm not aware of what he or Ms. Smiley may have told the county.
But you're aware that they applied for hay sales and tax sales and were granted that right?
I am aware that based upon numerous conversations with Mr. Breyer, he had indicated that he had obtained licenses over the years.
And is that what you're violating for now, is the operation of that same variety store?
I'm sorry, repeat that question.
Okay. I believe your due diligence had to do with looking into his defense and your violation, and you went to the county. Is that fair so far?
That's fair so far.
And were you able to tell from the county records that he went into the county and said, hey, I'd like to sell some hay and some tack?
And feed.
I'm not sure what he told the county in terms of securing the license. Obviously, he applied for that type of license, so I mean, I'm not going to make inferences, I don't know.
Don't the emails and the exhibit just entered make reference to hay sales and tax sales?
They make reference to those sales, but what I'm answering, sir, is I don't know what transpired in the conversation between Mr. Breyer and the county as far as what he intended to do in terms of his use.
Then let me make it a little simpler.
Okay.
Was the county aware that he was seeking hay sales and tax sales?
I would assume they are by virtue of issuing the license.
And the reference in the emails to hay sales and tax sales?
Yes.
That information came from the county, not from you.
No.
That's all I have. I'm the one who...
I gave you the exhibits. What exhibit number is the December 12, 2008 email? Your Honor, mine is not marked.
The first dated email, whatever came first chronologically, is 13. There's two emails?
Yes. So I want to reference the one dated Friday, December 12, 2008, and ask Mr. Cudney a question on that. If you could review the section regarding the paragraph that starts with 2006 application indicates. Okay. And could you go over that for the special magistrate?
Okay. The email indicates that the 2006 application indicates the licenses were issued as home occupational licenses through the tax collector staff. The documentation shows that Mr. Breyer signed the home occupation affidavit, which is good. The county indicates they may be requesting some of the licenses not be issued next year. And it further states we can remind the tax collector staff that only computer sales with drop shipments of goods is permitted from home. No stock and trade is permitted to be sold from the residence. It refers to an attachment 1 of the home occupation list. For those items to be sent to zoning for a sign-off include hay sales and nurseries, plant sales, stables, etc. It has a thank you, and then it says, from a history standpoint, hay, feed, and tax sales category is classified as agricultural sales and services, note 6, and is not permitted in the AR district. This location does not have a BCC, which is Board of County Commissioners approval for commercial stable or retail nursery. So many of the licenses he holds are not permitted.
Okay, that's it.
Do I have a copy of that as well?
Yeah, did you just give him, I think for the record, that would have been exhibit 13.
Let me just ask about that. The email is from Jenny Messina. Who's Jenny Messina? She with the county?
It doesn't give her name, but I have to assume she's from the county.
And who's Alan Seaman?
He would also appear to work for the tax collector.
Okay, so it was an internal.
Yes, yes, sir, it was.
So these are internal and not sent to you?
These are internal emails upon the
Wait a second.
So how would you get internal emails from Palm Beach County?
There is, are we missing a page? Because there is a sign off on one of them from Matthew Whitman. I think it's
Yes, sir.
the second page of paragraph 14. So that was an email from Matthew Whitman. Could you just clarify that so that we don't have any misunderstanding of what the records
Yeah,
are?
an email evidence report number 14 is an email from Matthew Lippman to Alan Seaman. It's come through Juanita James.
And who was Matthew Whitman?
Matthew Lippman at the time was the town clerk.
The town of
Waxahachie Grove.
Is he related to Dennis Lippman?
No,
No, that's Liv. No,
it's
that's-
Liv.
Okay.
And if you want me to go.
He's related to Fred Lippman. He's the president of NOVA. No, I just wanted to clarify. You had asked if they were internal or not, and wanted to point out one of them was from the town to the county. That's all. That was the only one to clarify, so there wasn't a misunderstanding on the record.
And I have a question for Mark as well.
Wait a second. And it should come through the attorney.
Yeah, I would say that here.
Write it down.
While they're writing there, what are we gonna do with the second case? Are we gonna have time to do it? You need to,
Well, they need to be, I didn't know about that. I'm not here for that case, so
Yeah.
I'll apologize, but we're here for whatever.
I know we have Mr. Ryan here for the next case as well.
Yeah. What time do you have to leave?
Around 1:10.
We have an appointment with the
In
county.
this case, potentially is gonna take some time as well.
the second case.
Yes, sir. Yes, sir. So.
And you need to be
Jupiter.
Jupiter at 2, so you need to be out of here by 1:15 or so.
It's not just a lunch date, it's paid, we've got to be in an attorney's office, we can't miss this appointment.
I guess the question is, what else does you respond to that?
Well, that aside, we're not
We're
gonna,
not, we're not calling anybody.
yeah, we're not gonna have time now to do their case. I mean, even if we finish in 10 minutes. Is it any problem from the town's perspective to continue the second case?
I don't have a problem.
I don't have a problem doing it 30 days.
When is the next meeting? That would be
Would it be
March.
30 days or could we do a different day?
We could do, I mean, we could do 2 weeks if you want to do it every 30 days. Or even tomorrow.
Want to do that?
I'm not sure. Tomorrow's good for me. I need to get to, I was a couple days to get to my office.
Well, then if you need a date certain, then probably would be better to go 2 weeks or something.
Want to do 2 weeks? What would that be, March? It'd be into March, wouldn't it?
March 6th? March 6th.
Sorry, March what?
6th?
March 6th.
What day of the week is that?
Wednesday.
That's probably, actually, Mr. Magistrate, that probably is not a bad idea in 2 weeks, because I know the regularly scheduled March meeting could possibly take some time as well.
Is it possible to do it in the afternoon?
I think that would be fine with me. Let's make sure we have enough time to do it, though. How long do we anticipate it would take?
Actually, I think that in talking to Mrs. Hastings, I plan on meeting with her possibly even as soon as next week.
Whenever you want me.
To make every attempt that we can to resolve the issue. But if we can't, then I'm assuming that it's going to take at least 2 hours.
Okay. Why don't we say 2 o'clock on
I'm gonna go right now and check on the availability of the room while we talk about it that way. we can determine.
Okay.
2 weeks, 2 p.m. is the tentative. That date. I think in courtesy of Mr. Ryan too, since he has been here.
I'm written more interested in verbal.
Okay.
Would you be,
That's fine.
you're okay with that?
Thank you.
We're gonna confirm the availability.
You have my number, call me and I'll meet with you.
We done?
We're just confirming the room.
Schedule a conference now.
Actually, no, I did not. Actually, yes, I did, I'm sorry. This is the water ready to pick up, and then the tea and the snack is working on, it should be ready to go. I'll let you meet the car, and we'll try to. Yeah, I mean, they're all in CC assist, all I have to do is just, create a version there.
Thank you.
So last year, I was on clarification, the continuance for 2 weeks. So I understand that if we are going to continue that, then I do not have a date.
30-day notice?
Might.
Maybe you wouldn't need to, because you've already given that.
Thank you.
Did confirm
Any
it's
irony,
not
that
regular
was,
time.
any irony, but I wanted to go in 2 weeks, and they wanted to go today, so we're going today, and they're going in 2 weeks. Your Honor, I have very little left, if that helps.
Okay. Just so we're clear on the record with the other case, that would be case 2012-311. We have continued that to March 6th at 2 o'clock. Okay, back to the question. I guess there is a question now that we're ready to ask.
Did you have any discussions, Mark, with Mr. Kilday, the land planner that Mr. Bryan and Mr. Smiley had previously used?
Yes,
And did you talk about the fact that it was a rather lengthy process?
Mr. Kilday called us for a conference call and future meeting, and yes, he did seem to have a grasp of the situation, and we did discuss the fact that, yes, it was lengthy and that he had a lot of work to do.
And did you agree with that assessment?
Yes,
When Mr. Breyer came in Friday with the application, did he ask for additional time to hire a different land planner?
yes, he did.
And did he suggest to you that it was a lengthy process?
Yes, he did.
And you obviously wouldn't disagree with that?
No.
That's all I have.
Tim? We're up here. I guess you're still in your case. Any other witnesses?
Yes, we call Braden. Is it Garrett's last?
Yes, bring here.
Did you have any discussions with Mr. Breyer about the application fee?
Yes,
Did you talk about how the amount would be arrived at?
I told him that I typically have no, inclination as to what it is, that I know that it's determined by usually Mr. Putney, the town manager, and that's based upon the cost of everyone's time involved.
And is that what happened in this case?
Yes,
Did you ever give him an estimate, in your opinion, of what you thought it would probably cost by way of estimate?
I told him that the typical fees that I had seen in my short experience at that time was around $5,000.
When did you tell them that?
It was late summer. I mean, it was months ago. I don't have a specific date.
And did you later tell him to bring in $7,500?
I never told him to bring in that amount.
You
That
know-
was determined here.
So somebody here told him to bring in $7,500?
Yes,
And is it your understanding that he did that?
yes.
It was never determined here.
That's all I have.
Any,
Nothing on that line of question.
okay,
You're under the respondent rests.
okay. Town have anything else to present?
Can I just have a moment?
Sure. Sorry you sat here for nothing here.
I'm sorry. He's been my neighbor for a long time.
Did we get a copy of this?
I believe she did.
We have not.
Yeah.
Okay.
And he explained it to you. The part on that, video, I kind of narrowed it down for you, so you don't have to spend hours, you know what I mean? But
Why don't you do this?
if you just listen, I think I got it for you.
I can't do that outside of everybody else, but when your attorney sends me the minutes or whatever, key me into where it is on the tape. You know, if it's minutes, whatever.
If you do from like about 18 to 28,
Okay.
somewhere in there,
Okay.
No, I have to discuss the first part. Okay.
For the time.
Mr. Brown is here.
Come here.
Susan,
I said,
what exhibit are we on?
no, we've already put this in.
Oh, we
Okay, go ahead, let's go on the record.
You looking for another receipt on this, or is that fine?
That's fine. Thank you.
what is the date on that check, Braden?
If it went on the record or not? Because we're not on the record now. You want to reopen and ask them?
Let's stay off the record.
I just asked him the date on the
Sorry,
check.
I'm just making sure.
I don't-
You get your answer? Okay.
The 15th.
Okay.
Yeah, I just wanted to make sure that was the date we were on it. Required.
Okay, well, there's a copy of the check in evidence anyhow.
Yes.
So we have the date. Okay.
Mr.
But
Gavin,
the town does have something to
I
present.
want to call one, recall one witness, Bev two, the code enforcement director. She did testify in October, but I want to call her and ask her about one line of questions, should they, hopefully briefly. Ms. Two, just refresh for the record, identify yourself and your duty to the town.
Beverly Tu, president of Two and Taylor Inc., here on behalf of working for Loxahatchee Groves Code Enforcement.
And I'd like to call your attention to town exhibit number 11, which is dated, which actually has an exhibit R-1 on it. It's the documentation relating to the code enforcement case in 2008.
Yes, sir.
Okay. Would you explain to Mr. Downey what occurred in this case and how it was transpired where it did not reach stage of violation?
Yes,
Can we
sir.
have a copy of that?
You should.
Well, we haven't been provided with one.
I'm pretty sure I did, but I can provide Mr. Brown with another, it's the copy of the documentation.